An interesting ag finance rule involving the sale of collateralized farm products, which is generally defined as an agricultural commodity. However, a recent court case from Kentucky brings into question of whether thoroughbred racehorses are farm products. Roger McEowen with the Washburn School of Law joins us now with a breakdown. Roger, let's start with some background on the farm products rule. What all do we need to know?
Well, good to be with you, Tammi. There's actually a very long history behind the farm products rule. Prior to a change in the law that came in the 1985 Farm Bill, the majority rule was that a buyer in the ordinary course from a seller that was engaged in farming operations did not take free of a perfected security interest. And so a farmer's sale of secured farm products did not cut off the creditor's right to follow those farm products into the hands of buyers, such as a grain elevator, for example. So that meant that if a farmer failed to settle with secured parties, buyers of those farm products sometimes had to pay twice unless the buyer could show that the secured party gave the debtor authority to sell the collateral.
Now, so what impact does this have on the ag community, and how often has it been updated?
Well, that rule significantly impacted ag financial transactions, as you could imagine. The major change occurred with the 1985 Farm Bill, and there were some changes made in the revisions to Article 9 of the Uniform Commercial Code around the turn of the century, and then also in the 2002 Farm Bill.
Now, does a buyer take the goods subject to a pre-existing security interest created by the farmer seller?
Yeah, this is how the rule was changed. It was reversed 180 degrees by the Congress. And again, that's that 1985 Farm Bill provision. So the rule is now, if you're a buyer in the ordinary course of business and you buy a farm product from a seller that's engaged in farming, you take free of a prior perfected security interest created by the seller, unless there were some very unique circumstances.
So let's talk about this Kentucky case. What are some of the highlights there?
Yeah, this was a lender that was financing a stable of thoroughbred racehorses, including the 2015 Triple Crown winner, American Pharoah. And the lender loaned the stable $30 million and took a security interest in just about everything that the stable had. It's a blanket security interest. And the stable sold some horses in its ordinary course of business, sold the breeding rights with the horses. And the lender claimed, you couldn't do that without coming to us. We still have rights. That didn't cut off our rights to go after the buyer. And so the issue was whether thoroughbred racehorses are farm products and whether the stable was engaged in farming, and the court said yes to both of those questions.
Very interesting. That's Roger McEowen with the Washburn School of Law. Appreciate your time and input today.